Hey everyone, welcome to the Paralegal Division's Power Hour. Today's presentation is called The Future of Legal Services Regulation and Enhancing Civil Access to Justice, which is presented by Michael Hulberg. Michael is the Director of Special Project at ILES, and he focuses on family justice and regulatory reform work, as well as promoting greater accessibility, efficiency, and fairness to everyone involved in the legal system. Hulberg leads our Allied Legal Professionals Project, our work on unbundled legal services, and ILE's partnership on the CATIE Initiative for Family Justice Reform. Hulberg joined ILES in 2018 after working for both private and nonprofit organizations. He started his legal career working with Towards Justice, a Colorado nonprofit organization that fights for workers who have experienced wage theft. Hulberg then transitioned to workers' compensation defense with Pollard Miller LLC, where he litigated claims on behalf of employers and insurance companies. Desiring to return to nonprofit work and help provide others with greater access to the courts, Hulberg joined the National Center for State Courts and worked on creation of a juvenile court specifically tailored to youth involved in gun violence. He's excited to increase the reach of his work to both state and federal courts through his work at ILES. Hulberg also formerly volunteered as a court-appointed special advocate, which involves advocating for the safety and well-being of children who have been removed from their homes due to abuse and neglect. Hulberg graduated from the University of San Diego School of Law in 2015. He received his Bachelor of Science in Psychology from Brigham Young University and is a member of Psi Chi, and I'm not sure if I said that right, the National Honor Society in Psychology. So thank you so much, Michael, for being here. Everyone, warm welcome to Michael.
Thank you very much, Rachel. I am going to, I'm going to share my screen. All right. So thank you very much for, letting me present on this topic. These are, as my bio talks about, these are things that I'm very passionate about. I will be talking about a number of different programs, but I'm first just going to talk a little bit about who ILES is, so like what I do, and why I work in this area. So first off, with our work, ILES works in a variety of areas: civil law, family, legal education, the legal profession, which is what I'm going to be focusing on today, and the judiciary. And with our work, we kind of have a 4-step process where we first conduct research or gather existing research. And then based off of that research and finding out what some of the biggest legal problems are, depending on what area we're focusing on, like if it is family law, we then bring together experts and leaders from across the country who are focused on this, whatever topic it is that we've researched. We bring them together to recommend specific models on how we can fix this problem, whatever it is that the research has shown that the problem is. We then work with local courts or Supreme Court justices, whether it's bottom down or bottom up or top down, to implement these models in courts. And then lastly, we measure it. So we want to see, the model that we've made, how can it be improved, what needs to be changed, and then we go about and do that, knowing that we try to get it right the first time, but that's not always the case. So before I go into the programs that I'm talking about today, I want to talk a little bit about the state of the legal system. You all have very likely heard about a lot of these numbers, but this kind of sets the stage in understanding kind of what's going on within the legal profession. So first off, 2/3 of Americans face at least one legal issue in the past 4 years, with just 49% of those problems having been completely resolved. That's obviously a very large issue. On that note, over 70% of civil and family law cases have at least one party that's self-represented. When you go into eviction and debt collection, that number in some jurisdictions jumps above 90%. So we have a lot of cases where self-represented people are showing up in court, and based on the research that ILS has done and that other organizations have done as well, one of the main reasons for this is not because they don't want to hire an attorney, but is because they felt like they did not have the funds to be able to afford an attorney, and so they felt like they had to go out and do it on their own. This is from the World Justice Project. The United States ranks 115th out of 140 countries for accessibility to court and legal services. I think with the numbers from the last stat I showed, that may not be, sound too far-fetched, but at the same time, hearing that the United States is 115th is absolutely nowhere that the United States should be, and I don't think any of us would be happy with that number. Between 40 to 75% of the needs of middle income individuals are unaddressed. That's obviously a very wide span, 40 to 75%. So whether it's dependent on jurisdiction, but lots of times when we think of access to justice and issues with people being able to afford legal services, we often think of people who, are in like the lower income brackets, but in fact, there are a lot of people that are considered middle income who are at the same time saying, I can't afford attorney services, so I'm going to represent myself in court. And then lastly, legal aid and pro bono services are not enough. I'm going to be talking about a program that focuses specifically on legal aid. And so this, this stat right here is in no way saying these are bad ideas. It's just, it's not enough. There's been research on this topic looking, because there's, been a lot of thought of, well, if we can increase the funds for legal aid, that will solve most of our problems. Or if we do required pro bono hours, that will also, really help resolve this issue. Some of the research has shown it would cost roughly $70 billion to provide just 1 hour of legal help to all households in America that are currently facing legal problems. So that's, I think that's a number that we're not ever going to get for legal aid. When it comes to pro bono, if every lawyer in the country did 100 hours more of pro bono work on top of what they're already doing, this would provide only around 30 minutes more of legal help per problem per household. So it's very specific, but it shows that, you need a lot more money for legal aid, a lot more pro bono hours, to the extent that these really aren't solutions in and of themselves to help solve this problem. I really like this graphic. This is from the Chicago Bar Foundation, so I can't take credit for it. I'm not sure how well you can see the slide, but there's rain coming down. That's what the blue is. And the rain represents legal problems. And then the umbrellas represent access to legal help. So you can see on the right side, the umbrella says corporate higher income. So these are people who, as it says, businesses, larger businesses and people with higher income, and they have this big umbrella. The rain is not touching them. They're able to afford attorneys and get the legal help that they need. In the middle, that's considered the middle class. A number of them do have umbrellas or have an umbrella that is over them, but there's still a lot of people that the umbrella is not covering, the rain's hitting, and that's that 40 to 75% that I mentioned. And then on the far left, pro bono and legal aid, there's an umbrella covering the whole thing, but there are holes in it. And so the rain is still hitting some of those people. And that showcases the lack of resources that legal aid often has to be able to serve, all of the people that they can. And I apologize for my voice. I am just getting over a cold, so sorry that it's a little raspy. So I'm gonna now go over 6 different programs. Each of these, a Juris Doctor degree is not required. Doesn't mean if you have one, you can't do this. Of course, you'd be able to, but it's not required. Some of these programs are decades old, dating back to the 1950s or the 1980s. Some of these are brand new, starting just in 2023 or in the early 2020s. And with each of these 6, I'm also going to talk about kind of 5 main areas. I'm going to talk about how many programs there are, or how many states have these programs. I'm going to talk about the backgrounds of these professionals, like their educational background and experience that they have, and then the training that these professionals need or have to go through in order to provide the services. And then I'm going to go into what those services are that they can provide. And then lastly, talk about supervision, because some of these programs require supervision, attorney supervision at all times, some don't. And so I'm going to kind of show the differences between each of those. So the first one, court navigators, over 30 programs. So this program dates back to the 1980s, and there's now over 30 of them across the United States. They are often created in partnerships that include the judiciary. They include access to justice commissions, legal aid leaders, bar foundations, and it's a primary goal of improving access to justice. That's why this program specifically was created. In terms of the backgrounds, we have both legal and non-legal, and by legal, I don't just mean attorney. I mean the wide range of different legal backgrounds that you can have, whether it's as a paralegal, legal assistant, and on. But a lot of the backgrounds that these professionals have, their court staff. A lot of times they are also AmeriCorps members, and then also students. So college and graduate students are also participating in this. And some of these positions are paid, some of them are volunteer. So it just kind of depends on the state and the program and the person. In terms of training, so I'm going to sound like a broken record, I think, with each and every one of these programs, but almost everything, it varies. So with this, it varies based on tasks and experience. So for example, there's a lot of training and learning that goes on in terms of the difference between legal information and legal advice. I'll talk about it in a second, but they cannot provide legal advice. And so it's very important for them to understand, what help they actually can give versus what they're not allowed to, so that they don't violate any unauthorized practice of law rules. They learn and are trained on descriptions of court service, or the court system itself, relevant legal and court terms, substantive law, and then legal and social service resources. So a lot of this is because it's, self-represented litigants are coming into court. These court navigators oftentimes are in self-help centers, but they, again, depending on the state and the program, some of these navigators are actually walking around the courthouse looking for people who look confused. Because there are even issues with self-represented litigants that miss their court hearing because they went to court on the right day, they were there early, but they couldn't find the courtroom, and they were too afraid to ask somebody, or didn't know who to ask about, where a specific courtroom was. and they miss a court hearing. And so even just having these navigators walking around trying to look for people who look confused is one approach that they've taken to be able to help them. And with like the understanding the legal and social service resources, these people also need a ton of different resources that are not located inside the courthouse, whether it's before or after their court hearing. And so being able to provide them with that sort of information is also extremely beneficial. The training comes in a variety of methods. They are trained through webinars, they're given written materials, they have some role-playing exercises, such as like completing forms and exercises like that to show that they understand certain forms, so they'll be able to help these litigants fill out the forms, or understand if the litigant has done it correctly themselves. They periodically have quizzes to make sure that they're up to date on their knowledge and still have the expertise that they need. There's also on-the-job, hands-on training. So there's like shadowing, there's observing hearings, and then there's follow-up training even after they become a court navigator, again, just to make sure that they know exactly what they're doing. In terms of tasks, so they're able to provide legal and procedural information, again, not advice. They can assist with legal forms and documents, and what that looks like depends on the state and depends on the court. If they provide specific like court packets or form packets for, like I know some states provide divorce packets for like contested divorces with children. They have a very specific packet that has all the forms for that. So it's a lot easier for the navigator to be able to provide litigants with that once they talk with them and find out what situation they're going through. They share information on available options that the litigant has. They give navigational, directional information that goes back to people trying to find their courtroom. They offer language assistance. And then they're even able to provide court they're able to accompany people in court. And that's on a very limited basis, where they might be able to sit next to them and just have, show them which document that they haven't presented yet, or if, they're getting flustered, they can ask to take a time out and have the person be able to, regain themselves. In terms of supervision, so it's flexible, depending on the amount of training and the amount of skill that the navigator already is bringing to the job. It just depends on what that supervision looks like. About 75% of the programs, they have dedicated supervision on site at all times where the navigators work. Although that, that's not every program. There are some where the supervisors at first, when navigators are new to the role, they provide supervision, pretty intensive supervision and guidance at first. And then afterward, it's just periodic supervision, observing them as they're assisting SRLs, just making sure they're following the protocols. Oh, I meant to keep moving this forward. Sorry about that. So that's about it for the court navigators. Again, I'm trying to just give a pretty broad overview of what these are, not going into too much detail so I can get through all 6 of these. Legal document preparers. So these are programs that have been going on since around the early 2000s. There's a handful of states that have these. The 2 that I'm going to focus on are Arizona and California. In terms of their education, so it's high school diploma or greater. In Arizona, these they're called legal document preparers. They have to complete one of a variety of educational pathways. So for existence, you can have, say, just a high school diploma, but then you need 2 years of supervised legal experience. If you have a 4-year Bachelor of Arts from an accredited college or university, then you need a minimum of 1 year of law-related experience. And then you can also have a Juris Doctor degree, and then with that, there's not a requirement for additional experience. They must also pass a criminal background check. And there is an exam as well that goes along with this that covers things like legal terminology, client communication, document preparation, and ethical issues. So that's Arizona. California is very similar with high school, that you can have a high school diploma plus 2 years of additional education, or a 4-year degree plus 1 year of education or of training. And then you can also have a certificate of completion from a paralegal program that's accredited by the American Bar Association. So that's about covers for the education and the training. In terms of the tasks of what they can provide, so again, now this is California. They can only provide their clients with legal documents and forms that have been published or approved by an attorney. So often in California, these legal document preparers are working with attorneys. The attorney tells them, these are the forms that you can provide for, say, somebody going through a divorce with children. Here are the forms you can give them, so that they can now give them those forms. Whereas in Arizona, you don't have to work with an attorney like that. You can talk with your client, find out what their situation is, and then just provide them the forms that you know that they need to be able to go through their case. And that's and so that's why the supervision really depends on the state. It's at most, it's minimal, with having the attorney just tell you in advance what forms to use. But it's not necessary in every state. I will mention legal document preparers, again, can provide legal information, but they cannot provide specific legal advice, opinion, or recommendation. And so that's why you see with California, why they need to work with the attorney to get that, because in California, they feel like it is moving from legal information to legal advice if you're telling them which forms you need to use. The third one is community-based legal advocates. So there are a handful of pilot programs right now. These are pretty new. It's just been in the last couple of years. With implementation of these programs really happening in just the last year or so. There is a program out of the University of Arizona College of Law called Innovation for Justice. And they're the program that has created these specific advocates. And so their work is primarily in Arizona, but they have also worked or are also working with Utah as well. And so these programs, there's 3 different kinds of them. There are programs where they're working to help domestic violence survivors. There's a program specifically around housing stability, and then there's a program around medical debt collection. So in terms of their education, so this is different from the others in that these are advocates that are already working in this space. So it's not somebody who is like, oh, this sounds like it would be, something I would like to do, but I am not currently working in it or don't have any of that expertise. These are people who've already been in it. And so I'm going to specifically talk about just one of the 3 programs, and that's the one helping the domestic violence advocates. So these are employees of a nonprofit called Emerge, and it's I think the full name is Emerge Center Against Domestic Abuse. And so these are people who have already been working in this organization. So it's an existing network of bilingual community healthcare workers. And then in terms of the types of training that that they need, so the 60 hours of training, 7-week course, and exam. So the 7-week course, it consists of both online and in-person instruction. This is specifically in order to train them to how to become a legal advocate. The program, it's hosted by the University of Arizona College of Law. And it's managed by an attorney coordinator and then taught by adjunct professors who are subject matter experts. And so I say the subject matter experts because the different types of areas that they're trained on are not solely law related, which I would say makes sense when it comes to domestic violence, because there's a lot going on in these people's lives, and a lot that's affected that goes far beyond the courtroom. But things that they're trained on, so they're trained on procedure, they're trained on care, they're trained on areas such as family law and child welfare, and then also on advice and counseling. And so they there's about to become a legal advocate at Emerge, you need 2,000 hours of work experience at Emerge. So these are also not people who are brand new to the program, but have been working there for a long time, already have a lot of that education and experience, really could probably provide this additional information and advice and legal help, because they've been working in this area so long. It's just because of with the unauthorized practice of law rules, they obviously cannot do so. And so this is a way to for them to be able to provide that additional help that they actually already have a lot of the knowledge of. There's a substantive law examination as well. So there is making sure after all of this training that they've retained the information and they are able to provide the advice in a competent way. And what I really like about these programs is that all of the training, all the education that they need to learn, all of this is free for them. And so it really opens up the doors for the type of people that are able to be part of it, to be a legal advocate and provide these type of services to other people. In terms of the tasks, so they can give legal advice, they can identify and advise participants regarding immediate legal issues, so how a domestic violence matter, how it affects housing, or what they need to know to protect themselves from financial abuse, or how to get an order for order of protection, or whether their immigration status, whether that is relevant to their legal options, because that can come into issue a lot as well. They can advise on completion of forms. And so this is, all the others have all the other programs I've talked about have also centered around forms. A lot of the research ILS has done, and again, other organizations have as well, have shown that one of the biggest struggles that self-represented litigants have is completing forms. Knowing which form to use, how to fill it out because of the legalese, even how to file it. So there's a lot of confusion when it comes to forms. So that's why a lot of these programs really focus heavily on that. They can help with case preparation, so they can assist in understanding what documents and supporting materials their client would need, need to save, need to bring to the hearing. And so they have all that information with them as well, so that when they get to court, because what happens a number of times when it's just a self-represented litigant is they don't have the appropriate documents, and then either depending on the judge or the rules of procedure, either the case is dismissed in favor of the other party, or the judge suspends or delays the case so that the party can either go to the self-help center at that moment to get the forms that they need, or have to delay the case weeks or months to have the appropriate documentation. So it really helps having someone be able to give them that. They also have a seat at the table to more quietly advise at hearings. So I mentioned this with like the navigators, but they can hand them a note, they can point to documents saying, what they need to use. They can tell the judge, that they need some time outside of the courtroom to better compose themselves. This makes a lot of sense, especially with domestic violence hearings, because of how emotional and difficult they can be. And so just having an advocate next to you telling the judge, I really just need a moment to compose myself, because I think a lot of people who are going into this alone and are at the table alone and have never done this before, they wouldn't know that they can tell the judge that or ask the judge for permission to do that, or feel powerful enough that they can do that, or confident enough. In terms of supervision, so with this program, with this DV program specifically, for the first 100 hours of their work, they are supervised by a licensed attorney. And then after that, there's not a requirement for supervision after that. So, 100 hours is still pretty substantial to for the attorney to know, this legal advocate knows what they're doing, they're competent, they can help them without my assistance. So the next one is community justice workers. There are a few, I'll go into this. So there are a few states working in this, not many. This is also a pretty new concept. So this has been, and with this very specific type of program, has been going on around 2019. And so 3 of the main states doing this are Alaska, Delaware, and Hawaii. I'm going to focus on Alaska and Hawaii for purposes of this presentation. In terms of education, so there's, again, a variety of educational backgrounds. Excuse me, with Alaska, it's not so much about education, but it is about training, which I'm going to get into with the next piece. But with Hawaii, these are, to be a community justice worker, these are advocates that are already currently employed by legal aid in some form. And what you need a college degree from an accredited university, or an ABA approved paralegal certificate or degree, or 7 years of relevant work experience. Training, it can be summed up that it needs to be done by the legal aid organization, but in Alaska, so the training is on the rules of professional conduct, including, conflict of interest, confidentiality, and duty of candor. They need to know the substantive area of law in which they'll be practicing, because there are just a certain number of areas that they can practice in. So they are trained specifically in those areas. And then also appropriate tribunal procedures they're trained on. And so especially with Alaska, there's there are like tribal courts and then your more typical district courts, and so they have learning about the appropriate procedures for each of those. In Hawaii, the training it consists of 14 classroom hours, 5 courtroom observation hours, and then around 20 to 50 hours of shadowing an attorney that are working on the types of cases that they can work on in Hawaii, which I'll get to those right now. With Alaska, so they can work in SNAP and unemployment benefits. They can help with will drafting. They can help with the Indian Child Welfare Act enforcement, or ICWA, debt collection defense, and then protection order advocacy. So there's a pretty wide variety of areas that they could work on in Alaska. Another thing I'll say with Alaska is that I really like about this program is that, and one of the main purposes for it is with Alaska and with how spread out it is in rural. And so there's a lot of people who live in areas where there aren't any attorneys, or there's, maybe one attorney working in there, and that attorney might not even live there. And so they might not be as familiar with the types of issues and just, how the people in those areas live. And so these community justice workers most of the time are people who grew up or live in the areas that they are now serving that population. And so it really helps those that they're working, because it's, whether it's somebody they know, so it's a familiar face, or it's just someone who much better understands the types of issues that they are going through. And so they feel more comfortable working with that person rather than working with somebody who maybe lives in one of the more populated areas of Alaska. Going on to the types of tasks with Hawaii and what they can do. So this is limited to family court cases that involve issues related to paternity, to child custody, and to visitation. So Hawaii's is a pilot project, and it's very limited to just those few areas within domestic relations law. Whereas Alaska is not a pilot project. The Supreme Court actually just granted a waiver, I believe, late last year, or as the beginning of this year, to allow these community justice workers to provide, this sort of information and advice. So a waiver to the unauthorized practice of law rules. And then supervision is pretty simple, with the education and training and how that has to be through the legal aid organization. The same goes with supervision. So each of these community justice workers, they are supervised by an attorney that works specifically for that legal aid organization. So everything falls underneath legal aid. All right, allied legal professionals. So I'm going to start by saying you may be thinking, what is an allied legal professional? There are a lot of different titles that are given to these professionals. I'm just going to name 3 of them or 4 of them to, in case one of these rings clearer for you. Limited licensed legal technician, or LLT, licensed paralegal practitioner, legal paraprofessional, or licensed paralegal. There's many other titles that have been given, but these are the professionals that I'm talking about. There are currently 7 states that have active programs or pilot projects, or in the process of implementing their program that their state Supreme Court has approved. There are many more states that are exploring this. So, well, first the states that actually have programs: Arizona, Colorado, Minnesota, New Hampshire, Oregon, Utah, and Washington. So it's very, at least right now, it's very heavily based on the west side of the United States, aside from New Hampshire. But with these other states that are exploring it, that have either developed proposals to their state Supreme Court or Bar Association, or have recently developed task forces that are looking very specifically at developing recommendations for this type of program. And those are spread more throughout the country. So we have Connecticut, we have Washington, D.C., Michigan, New Mexico, New York, North Carolina, South Carolina, and Virginia as well. And with, I will say with North Carolinians, I will give a shout out to the Justice for All Project and the work that they have all done in developing the recommendations specifically for their allied legal professional program, but also a variety of other programs as well. The educational backgrounds, so this again, like everything, it varies. But most states, they're allowing for about 4 or 5 different avenues. So you can have like a paralegal degree or certificate. Some do allow for just a high school diploma with a lot of additional education and training, but not many states do that. There is also a bachelor or associate's degree, a Master of Legal Studies. And then, of course, if you have a Juris Doctor, you can also practice as an allied legal professional. With each of these, you know, depending on the amount of education you have, you know, like if you have, say, just an associate's degree versus a Master of Legal Services degree, the additional educational courses that you have to take that are practice area specific courses increases, and which I think makes sense. And what I love about these programs is that all the education, training, and exams, it's all very heavily practice area specific. So it's not just, you know, learning the broad scope of everything within the legal realm, when if you're going to be getting a license to practice in family law, that is what most of your focus of education and training is in. So the training wise, it's an average of 1,500 hours of experiential learning, depending on the state, but usually it's a chunk of it can be general, you know, training under the supervision of an attorney. So it can be in areas outside of what you're going to be practicing. But a number of the hours, usually around like say 500 of the hours, so a third of the hours, do need to be very specifically in the area that you are going to be practicing in. So the sort of tasks that they can provide, it really covers almost everything. So there's legal advice, form completion, and that is, you know, from picking out the forms, filling out the forms, filing the forms, doing all of that. They can communicate with the opposing party. So whether it's, you know, in settlement or just negotiating, they can also, you know, do work with like mediation. They can be in there. Most states have not allowed for depositions because it's seen more as a task that an attorney would do, because it requires examining witnesses or questioning witnesses. And so a lot of times that's been left off of the types of tasks that they can do. But in court representation, so this again depends by state, but it's for some states like Arizona, they have allowed for full in-court representation. So what that means is that they can basically represent their client in court just as an attorney can. Most states have gone the approach of having limited in-court representation, where they can sit at the table, they can advise their client. The judge can ask the allied legal professional specific questions of fact about the case, and they can respond, but they are not able to question or cross-examine witnesses. And then supervision. So I mentioned that there are Some have some states have permanent programs, some states have pilot projects. So the two states that have pilot projects, being Minnesota and New Hampshire, they require attorney supervision. And the reason that they have done that is so they don't at the time have to change any of the unauthorized practice of law rules, but instead can just kind of put those off to the side for the time being, because obviously it takes a lot to revise those rules. So they're doing this pilot project and just waiving, or not waiving, but having attorneys supervise them and use the attorney's license at the time. For the permanent programs, there is not a requirement for attorney supervision, and so they're able to practice on their own, hang their own shingle, have their own practice. But what we're seeing, most allied legal professionals are working within law firms and still working with attorneys. And there's actually, in asking attorneys about, how that has gone working with these professionals in their law firm, this has, been a very good relationship where it's very like symbiotic relationship. And so it's kind of taken the approach of unbundled legal services, where the allied legal professional would do a lot of the work up to, say, in court, and then depending on the finances of the client and what the client wants, the attorney can take over and provide the complete full in-court representation for that client. All right, last one. I wanted to mention this one. So these are federal authorized representatives because, one, these programs have been in existence since around like the 1950s. So they've been around for a very long time. And I wanted to show at least one example of these programs in the federal space. All these other programs were more state specific, but there's actually a number of programs that have existed much longer than these state ones I've talked about. And so I'm going to focus some of the areas are public benefits, immigration, and civil rights, but I'm going to focus specifically on immigration. So I'll put both these in here. So must possess broad knowledge and adequate experience and be part of a DOJ recognized organization. So it doesn't have to be part of a very specific educational program, but there are programs out there such as Villanova's VISTA program, which stands for the Villanova Interdisciplinary Immigration Studies Training for Advocates, which is why you say VISTA. But this program very specifically teaches that broad knowledge and adequate experience that is necessary. There are two types of accreditation, and so that changes what type of education you need and training you need, and then what type of services you can provide. So there's partial accreditation, and so for that you have to submit a resume showing your education and immigration law experience. You have to show a list of all relevant training in immigration law and procedure, and that must include at least one formal training course that provides an overview of fundamentals of immigration law practice and procedure. And then lastly, you need 2 letters of recommendation from people who are familiar with the applicant's qualifications. And in addition to that, you need to be working for an organization. Oftentimes, I think maybe needs to be a nonprofit organization. It's nonprofit, federally tax exempt entities. And the entities themselves apply for recognition, which the Department of Justice grants. And then the applicant shows that they're going to go work for that already recognized organization. In terms of full accreditation, so they have to complete all the same requirements as the partially accredited, but in addition, they have to show that they have developed litigation skills through training, education, or through experience. And the reason being, For the partial accreditation, tasks go from it's mainly focusing on assisting people on forms that are submitted to the Department of Homeland Security. And so that's pretty much the extent of the partial accreditation. In order with full accreditation, you can then assist clients before immigration courts and the Board of Immigration Appeals. And so that's why with the additional training requirement of showcasing that you've developed litigation skills for the fully accredited. And then lastly, it's a lot that there is a formal agreement or arrangement that's entered with the organization and an attorney who works in this area of law, so that the authorized representative, if they have any questions, they have the contact information of an attorney that they can reach out to and ask. And so it's more of a mentorship than it is any actual like supervision, like looking over the shoulder, all of the forms. So that is the end of the federal authorized representatives and the 6 different ones. So I am happy to take any questions about any of these. Hopefully I will be able to provide the answer to them. I can't say I'm an expert in each. I will do my best. So any questions? Stop sharing my screen.
Great presentation. Thank you.
Thank you. I also know that it was a lot of very general information that I provided. I'm also happy if anyone would like to, do many of these programs or roles exist in North Carolina? No, they do not. Let me see, I'm trying to scroll through each of these and think. I mentioned the Justice for All project and the work that they've done with developing proposals for some of these programs, and that's the extent that I know of these existing in North Carolina, because my understanding is that the unauthorized practice of law rules are very strict in North Carolina, and I think that has impeded a lot of the ability to have many of these programs or any of these programs. So another question in relation to the state of the legal system, how do these programs rate in terms of providing more access to underserved populations? So what I will say is they are, the purpose of each of these programs is very specifically to hit these underserved populations, or at least that's one of the main focuses. So like the court navigators, and then the community justice workers. I mentioned with Alaska and how, not just underserved populations, but populations that are often just kind of forgotten about because they live in very rural areas. Some of these programs are very specifically targeted for that, and I'd say that these programs have done a really good job. The fact that the Court Navigator program has existed since the 80s and has only grown, and there are now over 30 programs across the US. It's because they are able to see that they are hitting these types of populations that are just often not getting the help that they need. And a lot of times the way that they find them is, only once they come inside the court for their cases. I'll say with the community-based legal advocates, they're trying to do more of a, before someone is getting to court, or really has maybe it hasn't even turned into a legal issue yet, they're trying to hit that. So really working upstream with that and trying to address the issue before it really becomes an issue, and providing them those resources that they often don't have, but very much need and wouldn't know about, until they go to court, or sometimes they don't ever even know about it unless they're able to, hear about it from nonprofit organizations like Emerge. I think that might be it, Rachel.
All right. Thanks so much for being here, Michael. That was a lot of great information, and we really appreciate your time. So thank you for everyone who was able to come, and for those of you who are watching this later, hope that you enjoy it. The Paralegal Division will be hosting a few more power hours in the new year. I think there's scheduled to be at least 2 in January. And those notices should go out before the end of December. So just be sure to register for those when those notices come through. Thank you all for being here. Have a great day. And thanks, Michael.
Thank you very much.